I am Dr. Vivekanandan. I hold the Ministry of Human Resource Development IP Chair Professorship at Nalsar University of Law. I was participating today in the best practices of IP management two-day conference of CII, and today in a session on litigations we discussed about what are the major issues, problems and how we are progressing. The speakers today spoke about importance of mediation in litigation rather than courtroom litigation, and speakers also talked about due diligence and how one has to formalize requirements for IP litigation. In fact, India is emerging as a very big power now, and intellectual property rights is going to play an important role, and one needs to discuss about how litigation should be cost effective, at the same time where mediations can resolve many of the IP problems involved in the country. We need to learn a lot from what has happened in Europe, where in the last 10 years they have done a survey how sometimes vexatious litigations can really block generic drugs coming to the market, and thereby the normal people may have a problem. So in this context, it's important that we realize that future IP litigation should be meaningful. At the same time, we have to see alternate methods of dispute resolution which will really benefit the petitioners as well as the defendants under IP. So today's program was basically about trying to disseminate to the various audience here, various stakeholders, about how IP litigations are happening in India. There's a tremendous amount of patent filing happen, and it is bound to result in litigation. So one needs to look at qualitative way of how to do this, and also importance of specialized courts on intellectual property rights which will resolve this kind of problems. So we have a lot of lessons to learn from other models in Europe and US, and probably not to fall into the same pitfalls, but to what you call as have our own way of doing IP litigations and qualitative IP litigations. IP litigation is basically about infringement of patents, trademarks, copyrights. This is basically what you call as IP litigation. It sometimes happens between different companies, innovator companies and generic companies on one side, as well as sometimes it may happen in areas of trademark. It may happen by people who pirate or people who do counterfeit stuff. Patent litigation, as I said, some big cases have happened in the recent 2 years, because in 2005 we changed the patent law substantially to align with global IP strategies, and so obviously you will find more amount of litigations coming in because of the product patent regime which is there. So these litigations could be of two types. One, lack of awareness by SMEs also could lead to more IP litigations. On the other side, there can be differences in terms of how generic companies want to operate and how innovator companies may strategize. So this is the type of patent litigations which will be happening in the future. See, in terms of litigation, the Patent Act is very clear about what is an infringement, but at the same time every law in a particular case has different interpretations how it is done. So hence it has to be argued properly, which means we have to strengthen the capacity building of intellectual property rights, and you all know that it is a combination of technology and law. So it is very important that technologists are also involved in this, and they do to some extent understand about what are the nuances of law.